Is your contract formed when you pick up the items from the supermarket shelf and place them in your cart? Or can the seller refuse to sell it even after you add it to your cart? Hello and welcome back to the channel and to the series that I like to call the Case Files. In this series, we analyze landmark judgments to understand why these cases are so important. Today, we are diving into the famous contract law case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Let's get started. Let's start with the facts. In the 1950s, Boots Cash Chemists introduced a new self-service system in their stores. Customers would walk through the aisles, pick up items they wanted, and then take them to the cashier to pay. Basically like any supermarket today. Sounds pretty standard, right? But it wasn't the standard practice back in the day. The Pharmaceutical Society of Great Britain had certain concerns about this system. Basically, they argued that Boots violated the Pharmacy and Poisons Act of 1933, which specified that the sale of certain controlled substances needed to happen in the presence of a licensed pharmacist. The crux of the issue was whether the sale occurred when the customer picked up the item from the shelf or when the item was paid for at the cashier. If the sale happened in the moment when the customer picks up the items from the shelf, then Boots would be in violation of the act because there was no pharmacist present at that moment. Boots, however, argued that the sale was not completed until the customer presented the items at the cashier where a pharmacist could oversee the transaction. So they argued that dropping the item from the shelf to your cart did not satisfy the requirements to constitute a sale, so therefore they were not in violation of the act. This is where your understanding of the law kicks in. In order for a contract to be satisfied, there are two fundamental requirements that need to be satisfied. First, there must be an offer. An offer is a clear intention indicating one party's intention to be bound. And second, there must be acceptance of that offer. That acceptance must be unqualified and unambiguous. It's only when both these requirements are met that there is a contract as far as the law is concerned. I've done a separate episode on it and you can check it out, and I'll leave a link to it in the description below. So in this case, it's important to understand who made the offer, who accepted that offer, and most importantly, when was that offer made? Was the offer made by the supermarket by displaying the items on the shelf? And did the customer accept by adding them to the cart? Or was the offer made by the customer when they present the items at the cashier and the cashier is the one who accepts the offer? The case finally went up to the Court of Appeal, and in its judgment, the courts held that in a self-service shop, displaying items only amounts to an invitation to treat and not an offer. An offer is made by the customer when he presents the items at the cashier, and it is the cashier who on behalf of the company accepts that offer by accepting the money of the customer. Therefore, the sale in this case was completed at the cashier under the supervision of a pharmacist. Therefore, Boots was not in violation of the law. So the judges explained that displaying goods was only an invitation to treat, the customer presenting the items at the cashier was the offer, and the cashier accepting payment was acceptance. This judgment clarifies the distinction between invitations to treat and offers in contract law. An invitation to treat is essentially an invitation to the customer to come up and make an offer to buy something. It's basically enticing the customer to make an offer. The impact of this case goes beyond pharmacies. It paved the way for modern self-service retail stores where customers are free to browse and select items before making purchase at the checkout. Without this ruling, the development of supermarkets and other self-service retail environments might have been considerably hindered. Even on some e-commerce platforms like eBay and Facebook Marketplace, etc., you can make the argument that the offer is made by the buyer who offers to buy the item. The seller is then free to accept the offer or reject it. By posting the advert on the website, the seller is only making an invitation to treat. But of course, this might be different in other e-commerce platforms. This varies platform to platform based on their business model. So the next time you pick up something from a shelf and take it to the counter, remember the legal framework that allowed for this convenience was established in the case of Boots Cash Chemists. Also, Pharmaceutical Society of Great Britain versus Boots is a good example of how legal principles evolve with changing business practices. Anyway, that's it for this episode. Hope you found it useful. If you did, please do consider liking the video and subscribing to the channel. And you can check out my other video on offer and acceptance next. I'll catch you in another episode. Take care. Bye.